was an item that the town attorney wanted to address prior.
Well, yeah, we're prepared to go forward. We have a staff report that's been circulating that you read. I did speak to Mr. Spicer before with the hearing. You know, a lot of times it's helpful to narrow down what the issues are and what you're going to be talking about. And I would suggest to the board to proceed like this. You've got our position, you've got our staff report. Mr. Spicer has some information he wants to provide to you about the appeal. This is not going to be a long contested matter. He has some things he wants to state on behalf of his client. At that point, the town can respond if we need to. But I think it would simplify matters if we proceed like that.
Okay.
Mr. Spicer?
Yeah.
Whichever you like.
What's that?
Whichever you like.
I'll stand right here. For those that don't know me, I'm John Spicer. I'm the attorney representing the owner, Cheryl A. Larry has stated our position. When we filed the appeal for the zoning violation, I had about a day before the appeal was due. So I initially felt that there was going to be the opportunity for us to appeal based on grandfathering in provision. After I researched it and looked into it, I came to the conclusion that was not going to be the case. So we're not really going to be taking the position that the property can be used in or contrary to the zoning rules and regulations that exist. The position that my client's taking today is that the violation was not one that was intentional or purposeful. It was one as a result of a contractual obligation that they had. Ms. Boone acquired the property, was renting it to parties in last year. The initial investigation occurred in October of 2010. At that time, she took the position that the unit or the building was two separate duplexes, one unit on the bottom and one unit on the top, and that they were not in non-compliance because it was two separate units. An investigation was initially made, but no decision or no results were ever determined for several month period of time. In that period of time, she turned over the management of the building or the property to a property manager. The property manager, in that period of time, entered into leases to begin in August and September of 2011 and go forward. Again, there was a determination or an assertion that they were duplexes. There was no finding that it was not a duplex. Believing that it was indeed a duplex, the contracts were entered into. In 2011, it became apparent that as a result of additional investigation that they weren't to be treated as a duplex. However, my client, being the property owner, was now contractually obligated under these leases that had been entered into to lease it to a number of individuals beginning in September 2011. My client has worked with the property manager to find and secure alternate living spaces for these individuals and has now been successful. I talked to the property manager today, who assured me today that the property, as of this week, will no longer be occupied by more than 3 unrelated individuals, so it will be in compliance. And so the position that my client takes is that it was not a willful or intentional violation. It was one done with the understanding or based on the position that it was a duplex at the time that the leases were entered into, that now that we have taken or take the understanding, and I've advised her that I don't believe that it does qualify for duplex and therefore she is in non-compliance, that she's worked to remedy it and will not be in violation in the future. And I've spoken a little bit with with Larry about what we're going to do in the future to secure or ensure that and I believe that we can work out something that's reasonable, that's workable for all parties. Thank you. Thanks. Oh, does anybody have any questions? Okay.
From the town's perspective, I don't know if you'd like to add anything about the facts and about the history that was just related.
Correct, right. And when the zoning violation was issued which was zoning violation 11001 in February 2011, that violation was based on an email from the owner stating that in October of 2010 stating that it was over-occupied. So staff worked with the applicant last year. There was no disclosure that they had entered into leases at that time. So we were working under the understanding when we went into the property in May of last year twice, and we did ask for leases at that time, and then also a month later that they were representing that the property would stay in compliance. There was no mention that they would be over-occupied as of the first week of the semester in August. And so that's where I would just like for that to be clear, that there were a number of conversations with the property manager that was represented as the official owner representative at that time, and that it was stated that in no instant was it stated that that they would be over-occupied again. At this time, there still is a question of changes that have happened to the unit that facilitated two-family dwelling. So there are changes that I believe that the building official would want to look into that include, that aren't limited to, there could be more, but include creating of a foyer downstairs, putting doors, an enclosed foyer, putting doors on 3 rooms that were designated on the original plan as not bedrooms, but are now being used as bedrooms upstairs. And then also where there was a dark lane shown on the original plan has now been changed into a kitchenette or a kitchen. So I do think that there is some further investigation that needs to be done by the town, by the building official, and by myself to ensure that everything that was done has been properly done under the building code, and then also that these changes did not create a legal unlawful second unit. So did not create an unlawful second unit. And so I do think that still needs to be investigated. So whether, the finding in today is that it's supported, that there was an over-occupancy in August, I still think that there is that question of what has been changed without the proper building permits. And does that create an unlawful second unit? So that's all I have.
From the town's perspective, I think it's, according to Mr. Spicer, this is going to come into compliance. I think the question for the board is, how do you want to handle what's before you, the zoning violations, appeal? More importantly, is there a way that we can structure something so that there's compliance in the future? So there are some requirements for example, we had a great discussion about permitting
unfortunately, I think it's unfortunate that we have to be here. Unfortunately, we may be to a point where some accept over occupancy, destruction of property, along with other disturbances as a normal condition. This needs attention. For this appeal, and it's good to hear that it's being withdrawn, but I think other cases of over-occupancy, fairness especially comes into question. When some can take an economic advantage and ordinances go unheeded. So I appreciate, and the neighborhood appreciates, the attention this board and the town is bringing to this matter. The fact that these matters have been taken as somewhat okay by some people is an unfortunate situation for this neighborhood. Thank you.
I wanted to address I'm Mike Hudson, 145 Wilson Avenue. I'm concerned that the withdrawal of the appeal has an interesting sense of timing in that it falls on the semester break and that the people are able to move out there, and that it's drawn out the process for an extended period of time, much longer than the situation needed to be tolerated by the neighbors over there. And I'd like to remind the board that there are penalties in place where each additional day is a separate instance here. And I'd like to, I'd like the board to calculate the number of days that this house was in violation and apply the appropriate penalty for that. Thank you.
John Melia, 202 Wilson Avenue. I guess I'm just a little disappointed that also the rental management company that played a role in this seems to be completely absent, as there so often are in these instances. And again, I just like to urge the town in general, and this board or whoever's involved, it seems like this whole process has been drawn out over a really long period of time, and it allows a lot of the situations to solve themselves, in which case the people that have profited from it bank their profits, and the people that have suffered from it have to suffer for a real long time. So I just glad we're all here taking care of this today, and in the future hope that these types of situations can be handled in a much more timely manner.
Thank you.
Anybody else? Okay, I guess. What are discussions?
I'd just like to put a motion on the table to deny the appeal, and we can discuss.
agree with you that, but again, it's taking staff time, but that's your jobs, to go and inspect the properties at the beginning of each semester and ask for the leases. Well, what if the leases aren't produced? And the same thing happens again. So I think levies and penalties might be appropriate because it might send a stronger message. And I too have a problem with the realty agent not even being here today, or the owner. And that's what I would say.
I'd like to comment also. It seems to me, I agree with the public comments that the timing is obviously suspicious. It's intended to get through yet another semester for the same sort of purpose. The claim that this was not willful on the part of the agency, if not the owner, I think is unbelievable. The prior violation was made clear, and the claim to bring the house under compliance was offered by the owner last time, and clearly they knew at that point that over-occupancy in this case was a violation, and they went ahead with it anyway.
Just
The
like
deliberate withholding of the leases for inspection seems to me a willful act of flaunting the law, and I think that there's absolutely no argument to be made that this was somehow an oversight or an accidental violation, that we were still somehow under the impression that this was a lawful two-family dwelling when the owner acknowledged the fact that it wasn't in withdrawing the last appeal. So I have no sympathy whatsoever with the claim that this was some kind of unintentional violation of the law. It was perfectly intentional and ought to be treated as such.
good and it's bad. Sometimes you can be more flexible, and that might be something that would have something a little bit hang perhaps over the property owner. But if they're doing what they represent, then it would also be something that we might be willing to agree to.
It may also be misconstrued by some members of the public that we're allowing the property to continue this way for a period of time, that we're giving them flexibility. I'm not so sure that that's a good idea.
Well, you wouldn't, the conditions would be that as of, not that you have until March to get in compliance, but that you're immediately get into compliance, and then January, February is where the compliance and in the new year, the new lease year is supported, documented.
If we vote, we have a motion on the table, and if we vote on that, can we still make these recommendations? And we can say in discussion that we recommend civil penalties, but we are not
It's
authorized to levy those.
Right. Your motion on the floor is to deny the appeal. The approach I suggested would be that you say the board moves to continue this matter subject to the following conditions. And I'm just throwing that out there. It may not be a good idea, but I was trying to think of something, and I think Mr. Spicer was trying to be receptive to that too, that no one wants to, certainly the staff don't want to be here again. Their neighbors don't want to be here again. And we don't want to send a message that this is something we condemn. So it's simply an idea to try to have a mechanism to inspect it.
It seems like the town is on it now. They know about the property, and I want to make sure that, and I think what you were saying, dragging their feet, you weren't meaning the town.
No,
Because Greg Dudash is the inspector for this process for all of the units that need to be inspected for the entire town of Blacksburg. So that could take some time in and of itself. But you meant the,
no, I mean in the case of the owner and the manager, yeah,
them too, but the town did go from October to February,
yeah.
so. But then after that, they were pretty much on it, so. I'm a little bit blame both ways, but.
That was part of the zoning violation has been resolved, so
Yeah,
there was
right.
no zoning violation
Right,
before you do that.
right.
In one scenario, if there were to be conditions for inspections, I would recommend that there be a series of inspections that the appellant comply with and agree to. First would be within the next day to 2 days, that they're in the unit and inspecting it to make sure that they are in compliance with the zoning district standards. And that they agree to an inspection in the next week to 2 weeks with the building official and myself to review any improvements that have been done without proper permitting, which possibly could lead to another zoning violation for the creation of an unlawful second unit.
Well, I mean, even if like one was a den and one was, put a door on it, I mean, you can have a door on the den.
Well, again, I do think that we can make that case and make it appeal that as well.
Okay.
But I do think that, again, it does need to be taken seriously that there's been work done with that permits.
Okay.
And that the work that has been done appears to have been done in order to create
Right.
2 units that can be rented out separately.
and
And so they did not proceed that, and they did not appeal the zoning violation that was the first zoning violation. You know, so there was no objection to the fact that we said that there was not a legally created second unit.
And I think one clarification, Mr. Spicer, I know that you had a short period of time to look over this, but in your appeal notice, you say that there was an allegation of over occupancy
if we delay it, a month or so? And then what happens next fall? I mean, is that the end of it? I mean, do we keep continuing
Well,
this motion?
No, because
You
this,
don't want to do that.
right,
so
yeah, this has to happen any day, for the town's sake. And so, the any day would be, wherever you hear the matter, again, you can't, this matter can't continue indefinitely under the BZA's
Right.
jurisdiction. And so there's a limit to what you can do with this one proceeding, and I'm trying to stretch it out and do as much as you can with this one proceeding. But before we get too much further, I'd like to ask maybe Mr. Spicer would like to weigh in and about this proposition I put on the table.
And as Mr. Spencer and I discussed earlier, the idea would be that as the good faith on part of the owner would make the property available for the future. If you vote today that you're not in compliance, as he stated, then it kind of takes the ability for you to come back into the property away. But as an effort to show good faith on the part of the property owner, that this is a matter that is resolved, that is a matter that will not come up, that it was not willful, we're willing to work with you outside the normal parameters, allowing you access to the property now, allowing you access to the property in a month, addressing concerns that you do have that we otherwise would not have to do. And I realize.
Does that suggest, or does that imply that at the end of that process, good faith process, and all things going well, the resolution of the questions about zoning and violations, does that imply that at the end of the day, we've more or less promised to find that there wasn't a violation? In other words, are we trading away the motion that's currently still on the table to find a violation? Or is it acceptable to this more informal process or more negotiated approach that we would still in the end of this process say, yes, it was in violation at time X?
I think if you do that, there's not particularly harm to the, it's not necessarily prejudicial to the property owner, it's still useful in the town to have that document. It's not, it's simply you upheld the determination, you weren't sending someone to prison or something
Right.
like that.
So it's acceptable?
Yes.
Okay.
Well, having just cause for an inspection can come from a variety of reasons. For example, neighbors pointing out that there's evidence, once again, of over-occupancy and so forth, that I think would serve just as well to follow up on the matter as us sort of declaring at this point that we're not claiming that there is a violation. It's true that the town can't randomly go and inspect the house, but neighborhood complaints, observations from drive-bys and so forth are all legitimate reasons for having a suspicion that there is another violation afoot. And I think that I trust that mechanism as much as I trust a kind of good faith agreement that this wasn't a willful violation, because I see no good faith in the claim that it was unlawful.
Mr. Kipling, the town's position is that either decision, either way you get is acceptable to us, and not trying to pressure you to ignore it.
I understand.
It's a little confusing because even if we delay the vote until March, we still have the same appeal to vote on.
Right.
Right. But what you're getting there is you're in the right to get in the house, and you're you're just continuing the matter for a couple months.
Okay.
Like I said, either approach you want to take is acceptable to us.
Will that
Maybe it would be helpful to, as staff, to try to clarify, please, comment on it if you have any thoughts on it, Larry. But if you are to uphold the appeal, or to deny the appeal today, then we could issue a civil penalty ticket, and would issue a civil penalty ticket it would be for $200, which the state code requires as the first amount that would be issued. Then within 10 days, after 10 days, we could issue another civil continue on that route until the maximum of $5,000. In this particular case, it sounds like Mr. Spicer is saying that the appellant it will be able to show that they've come into compliance within that first 10-day period. It appears that they would be able to show that so that they are in compliance, and with that, we would be able to have an inspection through that process. I believe if they are if they're able to show within 10 days that they provide once that civil penalty ticket is issued.
So the fines don't accrue from the time that the violation was found by the administrator, but by from the date of the filing of the appeals.
Well, they're told when you file an appeal, so that stops the clock, and they would only resume. Like, the idea of a civil penalty is that somebody, once you can do two things when you get a zoning violation. You can appeal it, or you can, I guess you can come to compliance. There's three things, or you can simply join the whole process. And if in this case the property owner said, very well, you said we're in violation and we're not going to fix it, then the civil penalty comes in, and that's your mechanism, you can issue it. Usually I think if somebody says we're in compliance, like they're going to say, there's going to be an inspection. But they only come into play after the fact is determined that yes, there's a zoning violation, and when somebody appeals it, the matter is, it's your appointed that makes a decision since it's been appealed.
You found there was a zoning violation in September, August, right?
Correct. Right, and then
And
the
the
appeal
appeal
period.
didn't start until October 24th, so
So there could be,
there's like a month and a half there.
No, they have 30 days to appeal, and you can't impose civil penalties during that first 30 days. So if he gets a zoning violation on September 1st, we can't issue a civil penalty hearing
Till October.
October 1st. And if they appeal during that time, the matter is told. After this, if you decide that there was a zoning violation today, then this clock will start again. And
Okay, it still seems like there's an extra month here. It was August something.
September when it is.
There's not.
The first month was an effort by town staff to have voluntary compliance and show either the lease or for the tenant, for the applicant to provide access to the house to show compliance as they did in May.
Okay, so,
So, that's what we would decide today, and what if we wait a month or?
If we wait a
Is
month,
that allowed?
then we would spell out conditions today of when those inspections would happen, before the matter comes back to you in March. And so there would be a matter of just spelling out the rough timeframes of when those inspections would happen and when leases would be provided.
but then if we came back and we still had to vote on the same violation,
And they were found not to be in compliance, then at that point, the civil penalties would be stayed until that March public hearing. And then if the appeal was denied at that point, then civil penalties could stay. scheduled for December of each year, and as luck would have it, they're actually meeting in December, which doesn't happen very often. And so it would be a matter